So let's start to wrap up these 2 days of excellent discussion. I apologize for having been absent in the last panel, but we had the UNIDROIT Foundation's Board of Governors, and it took longer than expected. So there's very little I will be able to say about that panel, but I thank God there's Anna to do that. So the idea of this panel is not, as I said the first day, not to draw on the conclusions of the discussion, because that's for Professor Hartkamp to do later in a way, but rather in the light of the discussion and with your own ideas. And that's an invitation to also to everyone in the room to think how we can improve and the principles, which way we should take the principles going forward, any ideas, also concrete ideas would be welcome. This is the beginning of an exercise which we'll do in a systematic and thorough way, should the Governing Council members agree with our proposal on 100 years, when we will have probably work streams analyzing all of our instruments for a long period starting after the summer and all the way into 2026. So this is in a way the first kick at the can of what we hope will end with a substantive set of conclusions and a way forward for contract law and UNIDROIT, because contract law and UNIDROIT have been together since the very beginning of the institution. So that will be a very important line of work. I was surprised that everyone found UPICC to be an ugly acronym, and nobody mentioned PRICKLE as an ugly acronym. I thought it was quite interesting, but I thought I might remind everyone that we do in our principles in the different editions, we do provide a suggested citation way, and it does say UNIDROIT principles, Article 1 UNIDROIT principles, and then the different years. So that's the preferred nomenclature, but so UPICC wouldn't do it. PRICKLE. We have to work on that, I think, Helmut. In terms of marketing in the English-speaking nations, we might have an issue. Okay, I think I'm going to be starting to ask the different chairs in order of intervention whether they can share some reflections on the route forward. The first one is Don Wallace.
Thank you, Ignacio. I have very little to say. I spoke about roots, but the key, I think, of our conference so far has been the future. Sorry. Thank you. Joachim made some suggestions. We should have correspondence in each country, the way UNCITRAL has the clout. He also suggested that we approach the arbitration institution of the world and ask them what they think about the principles, and even suggested a questionnaire be submitted to them. One final thing we might look forward to is the 5th edition of the principles. You know, we had the long-term contracts added in 2016. We have the agriculture, the insurance, and now possibly a project on international investment contracts. So I think, and also just from our own panel, there was a discussion as to how CISG influenced us and vice versa. And then Stefan Vogenaar spoke about the system. Do you remember that there's more than just that somehow having what we've done combined with UNCITRAL and the Hague Conference created a sort of a reality, which is a model and influences people, even though it's not, you know, an act of legislation or from the Security Council of the UN. So I think we have every reason to be very confident, even while we have learned that the actual practical application of the principles in individual contracts and in individual arbitrations, in effect, so as to affect the merits, is still very slight. But I think the motion is in the right direction, and we should breathe further life into it and go forward. Thank you.
Thanks, Don. Just by way of clarification, also, if it helps the discussion, a few things. One of them is one of the panels represented exactly developments of the principles which do not entail a fifth edition, but are rather sectorial applications of the principles, which would seem on its face the way forward. At least that's what the Governing Council seem to have agreed on. The principles on reinsurance is a direct application of the principles to a certain sector. Then we have the work we are starting on international investment contracts, on corporate due diligence, corporate sustainability due diligence. Those are sectorial applications of the principles, and that's for sure an area which the Governing Council has already decided to pursue. So the question, rather than should we continue that way, would be what other sectorial sectors would be maybe construction. I was looking at Chris, that's one of the things that I would like you please to reflect upon. The other one is, if someone advocates for a fifth edition, pure fifth edition, meaning not applied to a certain sector, but let's revise the principles. I think, I'm not speaking for the Governing Council, but I can't, but I do phrase the conclusions of several Governing Council discussions where they said, we don't want to go down that route again. And so if someone proposes that, explain why. I mean, what's missing in the current situation? Maybe, I'm just saying, to add more fire to the wood, whether a reason not to have a fifth edition, but rather to reconsider that and other instruments is, in light of technology, does it make sense to repropose any of the rules, to enhance them? Does it make sense or not really? And it's something which we don't need to do. So more elements for discussion. Would anyone like to react in the floor or from the, sorry, in the panel or from the floor before we move on to the next?
Can I just pick up on what you said? I mean, I'm not a contract specialist, but the principles really date from an era of sales contracts, of one-on contracts, of a pound of coal, or in my law school, it was the donkey dobbin. It was because we moved in a totally different world. Even when I saw it, even in the fourth, the long term, it was really a rather short-term view of long term. I mean, the world has changed. The whole world of contracting has changed. We saw that in another panel that if you really draft properly, there may be no room for the principles. I mean, it's a different world from the world that existed in the minds of people of 30 years ago who were graduated from law schools 20 years before that. So I do think maybe consulting, I'm a professor still, consulting a generation of students today, just for the hell of it. I wouldn't take them too seriously, but sort of get their off the top of the head reactions.
So I see Chris and I see Ulrich.
Yeah, thank you. You mentioned construction contracts. I don't have any firm view on it, but I think it is definitely something to explore more deeply and to see, is not that an area in which to pursue? There's certainly people in the construction industry who would very much favor UNIDROIT doing something like this, and there are papers on that subject that already exist. So I think it is something worth studying more carefully before a decision is made. That's my view. But can I mention a couple of other things just in relation to our topic this afternoon? Another impression I have of the principles, which are set forth, that we all know, as modern, latest, best rules for international contracts. And I occasionally, like I'm sure many of us here, talk about them to young lawyers. And one of the things that people notice and that comes up is that it's, in some respects, the principles are a bit old-fashioned. For example, they continue to refer to fax machines, telex machines. There's no discussion of electronic signatures. And I'm told that there are now modern forms of communication, which I don't understand, but which are not taken account of. So, for example, I'm told that under WhatsApp, there is no mailing address, although it's assumed in the principles there will be a mailing address in Article 110 dealing with notices. So I think particularly because we want to present the principles as representing the best modern principles, I think it's very important that those things are updated, even if it's not in a new edition. We want principles that really look good and modern and not not in the least old-fashioned. Another area where I think work could be done, because there's a lot of confusion and misunderstanding, and this is in an area of ADR, particularly expert determination and dispute boards. Dispute boards is now the state of the art for the resolution of disputes under international construction contracts, and not just international construction contracts, but because many people think dispute boards can work very satisfactorily under other long-term contracts in preference to arbitration and to avoid arbitration. There is a great deal of confusion about what the common law lawyers called expert determination. And dispute boards, to a common law lawyer, a dispute board is a variety, a species of expert determination. And there's a lot of uncertainty, particularly under the civil law. You go from country to country as to how do you analyze a dispute board? What is expert determination? And so I think the area of ADR, I know UNIDROIT does not want to get into arbitration, but before arbitration, I think there's a lot of work to be done because there's a lot of uncertainty around the world in that field.
Thank you very much. We it's up to the Governing Council to decide, but ADR, believe it or not, was already being studied almost 100 years ago by Ravel and the people that initiated the institute. And so we take note of dispute boards in construction and expert determination, which is a sort of glorified mediation in many ways. Can I just ask one question back? You described the FIDIC contract, and that's your specialty. We did receive here FIDIC leadership a few times over the years. They did show interest, although after they disappeared. But it was always present in their head and in our head. My understanding is that you said it yourself, I think. The problem of the UNIDROIT principles sometimes is they're too balanced. And what we want is more clear-cut solutions, clear allocation of risks. But I don't necessarily see that as something running against the principles. The principles can be supportive of hell and high water clauses as well, depends on how there's nowhere in the principles that runs against that. So what would, in your opinion, be the main problem, if there's any, in case someone decided to propose that we do work on FIDIC contracts and the principles?
Sorry, maybe I'm not clear. I certainly don't mean to say that the UNIDROIT principles are not balanced. I think
they're too balanced. Too balanced. So that the principles were too balanced. So
I didn't. No, to me, I find the principles fair, and I find the FIDIC contracts fair, which is not surprising because both have been produced by totally independent organizations. So, and without any axe to grind, which would be the case with some other standard forms of construction contract, which are produced by contractors. Obviously, they favor the contractor. The FIDIC contracts, if they favor anyone, they favor the person who produces them, which is the federation, which is the civil engineers. But the civil engineers are not parties to a FIDIC contract. The parties are the contractor and the employer, and the civil engineer is an intermediary between them. So they can produce what is generally accepted to be a fair contract. And I would also add that the General Counsel of FIDIC was hoping to attend this function today, because I think they'd certainly be interested in some cooperation with UNIDROIT, if that's what UNIDROIT would like.
Thank you very much. Proposal will be well received, of course. Ulrich.
I have a brief response to what Don mentioned a minute ago, that the principles sound a little outdated, not modern anymore. And I would caution to use that as a reason to rewrite them. I think it's maybe more convincing to take a holistic view, because we also have the parties who redesign their contract, to keep them updated, who adjust them to new developments. And contract law, as the principles contain, it's designed to last long. It's designed to be stable, to be predictable, not to change all the time. The courts will apply it. But if we think of the building in which we're meeting today, that's not a new building. It may not be the most modern one. But do we really want to tear it down and replace it by a state-of-the-art new concrete building? I think it works just fine, and the people in the building were modern and were filling it new. And I think that also can go as a symbol, as a picture for the UNIDROIT principles. Only change the wording if it is really, really, really necessary. And it's very well drafted. It says notice. It doesn't say email or WhatsApp. And if we would put it in the text, we would have to rewrite it every 10 years. So I think some reluctance is probably a good approach there, and to only react when we find that it is really necessary to supplement or to adapt.
Thanks. Well, we do have the black letter rules, and then we have commentary. So the commentary is easier to adjust. Ana, volví la parola. So I have next Pascal.
Yeah, you almost anticipated what I wanted to say, but my impression is that UPICC has been referenced by other UNIDROIT documents. And so as a center of the attention in a way, I think it would be important to have a renewal of the commentaries. And that could be done also in other formats, so that you have all the cross-reference directly. You have everything maybe useful also by digital systems and so forth. And in particular, all the AI contracting and these type of things could come into the commentaries. Because of course we will have the wonderful third edition of Fogenauer and his team on the commentary on the UNIDROIT principles. But if we have that in the official commentary as a nexus of all this, I think that would be very useful. Instead of indeed changing the black letter rule, does not seem so urgent. Thank you.
Thank you. Next, Professor Doralt.
Thank you. So I too would be skeptical about changing black letter rules. Yet, on the other hand, as much as I like the building, I am happy that you have installed electric lights and air conditioning. And to pick up Ulrich's metaphor, and I think it would be worthwhile perhaps having a working group permanently, perhaps even in-house, low-key, canvassing what developments would perhaps merit a change or an addition on the illustrations or commentaries, how to collect systematically, perhaps even more than now, court decisions. We don't know whether we overlook some of them, perhaps globally. And perhaps if then this points to the necessity of changes, considering whether there should be changes or not. Now, as much as this is a celebratory moment, and I mean, it's a huge success, I am not sure anyone could have expected those principles to be so successful and prominent as they now are. Yet, we should also see the big picture. If you take an enormous success now, the CISG, still in practice, even though we now have thousands of decisions, very often practicing lawyers say, I'm not so familiar with the CISG. I tend to tell my clients to opt out. Now, my personal limited experience is if you bring up the UNIDROIT principles, unfortunately, even though I really tried to make sure none of our graduates is among those, but unfortunately, as was mentioned several times today and yesterday, in practice, they're still simply not known very well. Now, that's something we can all work on in teaching and otherwise. The Wismut is great for this, but this is, as a starting point, one thing. It is of limited practical visibility beyond those who are already interested. Now, we have, nevertheless, this is why I referred to the CISG, in spite of the one angle being the glass half full with close to 600 cases, it is not a very significant number for contract rules or for a model set of contract rules. Now, it is by far not enough to breathe life into every corner of those principles to then really know which ambiguities arise in practice. It simply is not a relevant number in the sense of we can now really work with it, knowing Supreme Courts have decided 3 or 4 or 5 or 10 times on this or that principle. Now, how can we get more life into it and make it even more attractive. I think the commentaries to expand that and revise them occasionally is good. To reconsider black letter rules were necessary, and perhaps technology is one aspect. Perhaps the question of termination for cause, perhaps the question of whether molding everything around the sales contract is really true or is true in parts. Those things don't need to lead to a change. But if I now take again the analogy CISG and the principles of UNIDROIT, the enormous advantage, I think, structurally of our principles is they can be updated. The black letter rules of the CISG cannot, as a matter of fact, ever be updated on the black letter level. It is simply impossible to change the convention with so many signatories after ratification. Now, if there are evolving situations such as technology, different types of contracting, producing either guides for practice or changing them, I think that's advisable. Otherwise, it is difficult to get to a visibility of practical relevance.
Thank you. I have just one question for clarification. So you were proposing some sort of group like the one that CISG has for itself, which does a stable follow-up. Is that what you were proposing?
I would say at least this, and I would also be less skeptical about a 5th or 6th or 7th or 10th edition. I think it shouldn't be adapted too often, but perhaps once every 1 or 2 decades is perhaps suitable.
Yes, thanks. Professor Broderman.
I would go 3 steps further. Who are your addressees? Who are the reasons for the success of the UNIDROIT principles? That are your users. Initially, when you started, your main users were legislators, states. You still have an extremely well connection to states, and states then have legislators, and that shows, and that's maybe the most the biggest impact of the UNIDROIT principles, that we have see parts of them in so many laws. But in addition to the states, we have 2 other addressees. One are the arbitrators. I think they are our least room for trouble because they are usually educated and they start to learn it, although they would need some checklist. And I have little understanding for the ICC, which has stopped last year a project in which we had started in 10 countries to work on checklists for arbitrators, how to use the UNIDROIT principles. And when I find time, we'll continue to do that effort regardless of what the ICC thinks. But also that is a side issue because arbitrators are educated. Your biggest potential, though, are the practitioners. And I'm going to die out, I'm 66, I turned 66 this year, so forget me, in a decade, I'm gone. At least as an active practitioner. So we need to find the young generation. We have the Wiesmood called Alumni Association, for example. They are all already invigorated. We have to tap on these young talents and now look, how do they look? I told you yesterday in my speech, nobody has time. So we have to use the modern media, and nobody looks at any clip which is longer than 2 paragraphs or longer than 30 to 60 seconds. 2 clips or maybe 2 minutes. Once in a while, a podcast. And with that said, we have to, I would propose to you to consider and to discuss what kind of format you could kick off. Of course, as UNIDROIT, as an international organization, you cannot sit down and work every day on a WhatsApp format or on the LinkedIn. When I looked at the LinkedIn page, what UNIDROIT does is every few months, and that has already become much better than it was, in an announcement, there was a certain mission, there was a conference that shows UNIDROIT is out there. But it does not help, it does not serve the need of the young users, age 35, 40, what's in for me? And what's in for me is the little clip. The clips going down. In July last year, I did a video clip with interviewing an American in-house counsel. And then I took a team on private cost, I did that, to edit that. Then I took a team to slice it down to 13 small clips to 2 to 3 minutes. And now over a period of 6 to 18 months, I'm sending out these clips every few weeks when I think of it, and there's basic instruction for that. I send a new clip. And like this, it's each time a little nudge that's out there with one practical aspect. What can I do in this situation? How can I use it? Take the issue of notification. We have excellent language in 1.10, by any means appropriate to the circumstances. That of course includes emails, the commentary. So my whole purpose of this is in a way following up on with the new light, etc., instead of spending much more time whether we need to adapt any of the excellent black letter rules. More important is to find modern schemes to reach the young generation users. And that's a young generation. They work, they have hard pressure, they have other points which are not the law on top of their sites. The kids, the children, the childcare, the part-time work, the mobile office, the seconds, the multitasking, all that. And we have to reach them there so that they open up to the UNIDROIT principles.
Thank you. Well, we are an intergovernmental organization, and there's a limited, we are not going to open a TikTok account. I mean, we can, of course, we would think that's universities that would take care of those things, and when they modernize their teaching systems. But I mean, we have a YouTube channel, we have a Facebook account, a LinkedIn account. They are all quite successful, I think. So have thousands of followers. But we have, as you know, very limited staff. But the point's noted, thanks. We need to do better on dissemination. I would imagine that's what you mean, and make it. I always had mixed feelings about my colleagues, about the importance of UNIDROIT being and UNIDROIT instruments being broadly known by the world community. We want to reach the legal community, but I'm not sure we want to be very famous between 16-year-olds, because I don't see much potential there. It's also not our job, but I could be wrong. And so maybe we should revisit that idea. Anna, you wanted to?
Thank you very much. I have one very practical point which might be not that important, but the UNIDROIT principles now have a date. It was 2016, and they always had a date. So that is perhaps something that we might wish to change, because dates, unfortunately, become outdated. That's what they do. And so in 2026, when we have our centenary, it will be a long time ago. And I think especially it is true that, civil codes, laws, even case law is cited, which is much older. So it's not that practitioners always only look at the newest bright thing out there. But at the same time, that might be a cosmetic but important thing to consider. And the second point I wanted to make is that I very much agree with the idea of accompanying the UNIDROIT principles with explanatory notes or guidelines or additional documents that might better explain how they apply, taking into account certain developments in practice, which are also, for example, linked to technological developments or other possible developments, short of having a completely new project or a complete overhaul or revision of the principles as such. And the last point, the third point would be, I was very interested in what, Chris, you were saying about the possibility of thinking in terms of a more specialized use of the UNIDROIT principles as general contract law in the sector of construction. This is something that has been repeatedly tried in the past, but perhaps a good time to resume discussions on that. And this brings me to the point of the the form of this type of instrument, which goes in the direction of perhaps putting together principles like the ones you find in the UNIDROIT principles and rules, and something which is more akin to contractual clauses applying in practice in a specific sector with more details the general rule, or perhaps sometimes deviating from the general rule because that particular type of contract needs a deviation. And this might be one way of addressing the issue of ADR, because we are not an organization that deals with ADR in general, at least now in our history, but we have referred to ADR in instruments such as the legal guide on contract farming or other instruments where the idea of solving disputes, first of all, and secondly, even in other sectors like hardship rules, general hardship rules might need concretization in certain in contracts, because you want to give more, and this is what the UNIDROIT principles already say, you might wish to give more details on how to conduct the negotiations or how to ensure that adaptation goes in a certain directions, and perhaps even minimizing the exceptionality, because you want this to be something that can be used in different circumstances. So that those might be ideas for the future. Thank you.
It will be a combination of the ADR proposed by Chris, dispute boards, expert termination, linked with our hardship negotiation as a solution, for example. Okay, next chair, Tirado.
Well, thank you.
Okay, please go on. Sorry.
You're going to talk about ADR. Something that has been revealed to be missing in the dispute resolution sphere is a definition, an agreed definition of what is an arbitrator. For example, under the New York Convention, there isn't actually a definition of what is an arbitrator. And I've seen recently that people are struggling to distinguish between the kinds of dispute resolution mechanisms that are now popping up on blockchain, for example, and smart contracts and things that I don't really understand. But there are dispute resolution mechanisms, and the question is, are those jurors, for example, under a system called Kleros, are they arbitrators or not? And that's something that perhaps UNIDROIT could make a useful contribution that would be helpful to a lot of courts in a lot of situations.
Thanks. That would be institutional ADR in principles would be detached from the principles, but maybe someone else might comment more intelligently than me on that.
Well, thank you. So going back to our original question, what could be a way forward for our work at the UNIDROIT? And let me first say that it has been an incredible pleasure. It's been very inspiring and interesting to participate in these 2 days. So many interesting panels and discussions, and what I was thinking, trying to find out what could emerge out of these discussions, particularly the discussion in the panel that I chaired yesterday, but also the other discussions, and what actually Anna was just saying as well, because these issues are linked to each other. What I was thinking, one possible way forward would be exactly to try to identify those areas where principles are useful, needed, but too general to be operational, and try to proceduralize a little bit, like Anna was saying now, like Chris was mentioning yesterday as well, create procedures that would permit to implement those interests, those values, and those principles in the form of a contract clause, plus possibly, or in some other form, so that the hesitation that we heard is to be seen in practice with respect to the application or the reference in general to the UNIDROIT principles, that hesitation could be overcome by showing that there is a specific instrument that is actually pursuing a purpose that is actually useful and that is going to have an effect under certain circumstances. And we are in a certain way going in that direction in the group on investment contracts, because now we are at the beginning of the work, so it's too early to say anything clear, but in some subgroups at least, we are discussing the possibility of adapting or creating a text that permits to render the general principles more specific and operational and applicable to pursue the purpose that we think needs to be pursued. And then now I need to be specific myself, because otherwise I continue being on a very abstract level, and it's not operational what I'm saying. So one of the issues that emerged in these days, I have heard it discussed in at least 5 panels. And of course, I've heard that particular issue because it has been my fixed idea for many, many years, is the principle of good faith. The principle of good faith, which is so important in the UNIDROIT principles, in the UPICC, and yet can be understood in so many different ways, depending on the legal tradition of who is reading the principles. Just here during these 2 days, we heard a range of explanations of what the principle of good faith means. From yesterday, we heard nobody in no legal system would ever assume that the principle of good faith can be used as a basis for creating new obligations for the parties. That's we heard yesterday. And today we heard that the Dutch and the Japanese courts, they have prevented the party from exercising the contractual right to refuse to renew the contract, or they have created other obligations and so on. So that you see that there are different ways of understanding what is the range of this principle. And it seems to me that creating a document that by use of cases, examples, illustrations, etc., clarifies and permits to give a uniform understanding of what otherwise is so loaded with legal traditions that per definitions are different from one country to another. Doing that could be very useful. And it could be a bridge to another area that we have heard both yesterday and particularly today, could be an area of development for the UNIDROIT, which is the ESG. We heard of, speaking about good faith, yesterday Pietro was mentioning that the very balanced nature of the UNIDROIT principles would in itself be a possible, what did he call it, a green sticker or something, that something that you can hack and it gives you more score in these evaluations about your sustainability. Today we heard about how good faith could be used, and I'm not going to talk for the other panels, so I will stop here. But in any case, it seems to me that working in a conscious and operational way on clarifying the range of the principle of good faith in the UPICC could be a very useful contribution that I think actually would make the UPICC easier to digest also to those practitioners who suspect and do not want to refer to them as an applicable law.
From formal standpoint, how would you develop that?
Yeah, how would I develop that? There would be, yeah.
An additional principle, it would be a commentary with a separate paper, it would be.
I think it could be an addition to the commentary, or it could even be a leaflet as on its own, saying that what is the range of the principle of good faith, because as I told yesterday, the words good faith are mentioned 37 times in the UPICC, but they are underlying the whole instrument, so that it's not enough to say what good faith is in the comment to Article 1.7, you would need to have a holistic understanding of what it entails. And I could imagine that it could be, but I haven't really thought about those details, but it could be both an addition to the comments to the with illustrations and cases, to the comments to the black letter provisions where it is relevant, and it could be collected also into a specific leaflet.
Ignacio? You know, we have a narrow volume called clauses, how you can use. Why not have a little volume just called good faith?
Joaquin, you wanted the floor? No. Yeah, yes. Someone must give you though the. Sorry, why don't you, if you can, sit. Maybe sit here. Yes. Thank you.
Well, we have heard a number of very interesting, stimulating suggestions. But in order to, I'm not going to anticipate what your final task will be, that is to say, to extract the quintessence of the discussion here, but isn't it that the common denominator of almost, if not of all, the interventions so far made in the discussion are directed to assist parties in using the principles? Because obviously, I mean, this is an old story, general part of contract law, and then comes the specific part, types of contracts, and in between there is party autonomy. Therefore, an invitation to parties to frame the general building of general contract law to their needs and expectations in the specific case. Not necessarily, again, an abstract approach to this or that other type of contract, but to illustrate the different, good faith has been invoked quite rightly, ways in which good faith may be rendered explicit. And to a certain extent, it is already in the latest edition of the principles, here and there in the comments made. Think of provision, I can't remember now what it is, 18 or something. Parties may agree to negotiate in good faith. This is a fairly common attitude in certain situations. What does it mean? And then the comments, in a very short, concise manner, gave 1-2 examples of what parties could add to that formula, negotiating in good faith, for instance, to fixing procedural rules, time limits, etc., etc. Yesterday, I myself dared to refer to a fairly extensive comment introduced in the latest edition to 4.3, relevance of performance after the conclusion of the contract. In their example of model clauses, which again can be adapted by parties in each case, but you have already a first indication. Shall we set up an advisory committee monitoring the performance of the contract, or shall we leave it still to the parties by saying if a party intends to deviate, at least in his mind, from the original agreement, issue an order of variation and see whether you get the acceptance from the other party. I mean, these are all very specific, concrete examples to which I could imagine one could easily add, thanks to the input of those who are familiar with certain types of contracting, enriched with further additions. And this, I mean, I would imagine, sell extremely well to practitioners under a title very simple, Guide to the Use of the UNIDROIT Principles, and have obviously a very detailed and finely refined index content, so that with the key concepts, practitioner finds immediately, good faith in negotiation, in performance, in interpretation, and parties may, in order to avoid uncertainties, etc., do this and this other things. This I personally would consider interesting addition to what is already on the table.
Thank you. Reggie? No. Okay. So I have Sir Roy, and then you. Sorry.
Thank you. Another very interesting set of discussions. I was once asked, giving a lecture in Rome, why English law did not have a general concept of good faith. And I said, well, the latest edition of Staudinger on the BGB, German Civil Code 242, which is about 4 lines long, ran to 500 pages of small print. And I said, that is why we have no general concept of good faith in English law.
Professor Massenet?
Yeah, thank you. One of the difficulties that are facing applying the UNIDROIT principles is that the national judge or arbitrator use its own law, national law, domestic law as a benchmark, and does not account to the international character of them. I think this damage the value of the principles, because a specific performance under the principles is something different from specific performance under the civil law of one country or that. How can we reach to the point that those national judges or arbitrators or even legalists understand and apply these principles, accounting to their international character, and liberate their minds from their domestic law?
That's a difficult question. Jose.
Thank you, Ignacio. I think time is not ripe yet for this discussion, but I submit that if eventually the working group on investment contracts detects that we need more principles to govern these long-term contracts, then I wouldn't go the way of having a standalone instrument. I would enhance the principles, because I hope I made the case with my presentation today. These additional principles, if we detect that they must be there, they should be equally applicable to investment or commercial contracts long term. So eventually that could be an enhancement of the current version of the principles. I wouldn't make it a standalone instrument, because its provisions will be also applicable to international commercial contracts, and it doesn't make sense just to have 2 instruments in that case.
Yeah, yes, I would also very much favor developing the principles. I remember about 20 or 30 years ago, I think it was UNCITRAL put out a big, thick guide to international construction contracts. That was not the exact title. but it was a big, thick guide like that. And that's the field I've been working in for the last 50 years. And I found it virtually useless. A huge amount of work had gone into it, a lot of generalities on different issues in construction, but I found it virtually useless. I like the word that Judita was using, operational. I think that's what you should be producing is operational. And I consider the principles to be very operational. That's the kind of document that is useful to practitioners. It's concrete. It's clear what the black letter rules are. Indeed, they should be explained by commentary as they are. That could be developed. But I'm very much at least I would very much support that kind of work by UNIDROIT rather than producing guides. And indeed, I'm a bit skeptical about the investment contract working party, but that's another issue. But again, because of its generality and undefined nature.
To that project, but it was the Cold War. So we started, that's why it happened. We started on a book. Then at the end, when the Soviets and the Americans became friendly, we put the clauses in the footnote in the 5th year. You're totally correct, but it was history. I recommend the reading of history to you, Chris.
You want? What? I'm ready. The floor is yours.
No, one reaction. I mean, I don't know why Chris doesn't like the working group on investment contracts, because I think there is a lot of overlapping also on what you do in construction work, and so one thing that I think it was already discussed by the governing council in the past years was also multi-party contracts, which is one of the issues that come up with investment contract. And I would expect also in construction. I mean, when we speak of investment contract, we do speak a lot also of construction contracts. So it's why I don't know. I mean, but in any event, multi-party as one point, and possibly also some consideration on parallel contracts or contracts that are functionally linked one way or the other, which is something that I would understand might also come up with the supply chains work somehow. So these are, I don't know whether these are things that can be taken into consideration in the principles. But for the rest, I must say that for our panel, I don't know whether the other participants agree. You already put on a lot of good ideas on how to track case law, how to try to see differences in application or in an application of the principle. So I don't see anything else that we can advise in addition to what was already said on possible working groups or networks of contract lawyers, in-house lawyers, or things that could help us to not only to disseminate the principles, but also to let's see how the principles can indeed help in the working on the daily writing of contracts in general. I don't have anything else to say. I mean, in terms of what we can do more on the principles.
Eckhart.
Ignacio, thank you. On the issue of dissemination, the third group are the arbitrators. If I were in your shoes, I would consider discussing with your governing body how to use efficiently, without using too much of the resources of UNIDROIT, to get the dissemination done indirectly by using all these many arbitration institutions, not only ICC. Article 35 of the Asian European Arbitration Center, for example, explicitly mentions the UNIDROIT principles. That's few. But everybody, just about everybody of the 800 arbitration institutions plus the 200 Chinese ones, last CTAC since January this year they changed the rules and explicitly admit in the new Article 53 since January 2024 that you can choose general principles of law. And whenever they do that, that they use rules of law, principles of law, that in the end there comes a formal letter, but that a working group would need to prepare, or somebody would need to prepare how to write that letter, and give them a model clause which they could add in as a footnote in the arbitration rules. Imagine if we have the arbitration rules around the globe, which all in the rules have a footnote, that by rules of law you could consider choosing the UNIDROIT principles. Then you would have a much more bigger indirect dissemination effect. Thank you.
Thank you. We do have an open dialogue with many arbitration institutions. Some of them, for example, in Shanghai, in Wuhan, in many countries in the world, really. So it's an open dialogue, and we understand that to the extent that large arbitration centers do use the UNIDROIT principles, that will be a source of application and will multiply by several factors the use of the principles. As everyone knows, our main problem is that the principles are actually much more used than we know, because the words are not always or are often secret. So our dialogue with the arbitration centers helps that. Is there any reaction on Maria Chiara's reference to multi-party contracts and contracts that are functionally linked, which obviously links directly with the supply chain, which is part of our work?
I think it's an interesting comment. I think the principles actually work with multi-party contracts, and I think they work in supply chain contracts. The flexibility built in, someone suggested earlier in this discussion, the principles sort of directed towards sales contracts, and that's not actually true. We heard yesterday a breakdown of the reported opinions, and sales contracts were something like 20-some%, which is not insignificant, but it's hardly overwhelming, and deal with all sorts of contracts, agency, insurance, blah, 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 and which is because of their flexibility. But on the issues of multi-party and supply chain, my sense is that the principles work very well and are adaptable. People may disagree.
Thank you.
Sorry,
Chris,
I would like to strongly support the idea of multi-party contracts principles. Firstly, from the point of view of group of companies, when many contracts are made by mother company and daughter company, is one thing. The other thing, consortiums. So it would be very important to divide the risk between some newcomers to the contract from one side. So finally, I strongly support this idea.
Thank you. Christina, sorry, it was Chris and then Christina, sorry.
Well, the principles already deal with joint ventures, because I think it's chapter 11 dealing with co-obligors. So you've got the principles there, I think, already dealing with multi-party contracts.
Yes, I would like to echo that, but maybe the comments could be supplemented with more concrete illustrations and examples of how to deal with multi-party contracts. And the very problematic matter of functionally linked contracts. That is not very clear from the principles how to deal with them. But I think they can accommodate that problem, but it would be useful to have some illustrations.
Management of the commentary, Helmut?
Well, just to mention that you're talking about multi-party contracts. I assume you mean a contract where, at least on one side, there's a multitude of contractors represented. In reinsurance and also in large insurance programs, you have a similar yet different situation. You have so-called liability towers, where the risk is split by layers. One insurer covers the first million, the other one the second, the third million. And each layer is not just covered by one insurer, but by several insurers or reinsurers, forming a so-called co-insurance or co-reinsurance. Now, I think certainly for the German-speaking world, but also internationally, we consider those contracts to be separate contracts with no joint and several liability of the insurers and reinsurers. So it's not a multi-party contract; it's a multi-contracts, but a network of contracts. They are connected because the wording may be identical, and the insurers even form a consortium in the sense that one will take the lead and administrate the contract. And certainly, it's strange to see that very often the arbitrations are split. The policyholder will arbitrate against insurer A and B and C separately, and theoretically there is confidentiality, so you do not know how the award what the award reads against A while you are still arbitrating with B. I always wondered whether this is an efficient way of dispute resolution, and I always thought this was more an arbitration issue. But of course, maybe the underlying contract principles could somehow consider this network issue as well.
Yes, the consortium agreement, of course, in an ideal world, should deal with the arbitration problem in these kind of contracts. I think it will be extremely complicated for the UNIDROIT to solve that problem through principles. But I still think it is wise to address it in the comments and illustrations.
Following up on the same general topic, wouldn't it be a possible way to start by analyzing the arbitral awards and court cases that we do have and see to which extent that has caused any problems, multi-party, but also back-to-back transactions that often don't end up in the same procedure. And then once we have seen whether that has worked well and what has not worked well, one could take a second step and see how one could avoid overlaps with group of companies, having other companies being liable for a non-contracting or a non-contracting partner being liable for contractual debt. That may go very far into the area of company law. But in order to see to which extent it is distinguishable and how one would distinguish it, probably the analysis of what we have until now would be a good first step, and then see what one could make of it.
Thanks, Eckhart.
I'm skeptical there because in the end, it's businessmen who make the business. And I've seen all philosophies. It depends on the businessmen whether they want to have dispute risk shattered, separated, or joined. Among the examples I gave yesterday, many of them are multi-party contracts. Very, very often, it's a group of companies of 20, 30 people or companies in different jurisdictions on the one side and same thing on the other side. It happens. And the UNIDROIT principles function very well. I've done several assignment contracts, several contracts using the chapter on obligors and on obligees. The only point, but that is inherent, it's our the little drop, we don't have a real default rule on 11.2, and sometimes that's forgotten and makes it difficult in practice to bring up that point because we know we have these different opinions around the globe. Just a point of information, UNCITRAL is, I'm not involved, is studying concurrent proceedings, many of which arise out of these contractual arrangements. So any research we do here would be useful to consult the Secretariat of UNCITRAL.
So we are actually doing work on a related topic. It's called a project started at the request of the United States, which is the collaborative legal structures and agricultural enterprises. And for the time being, what it's doing is comparing a network of contracts, cooperatives, and certain types of corporations to see whether and how to better structure agricultural enterprises, especially in the lowest part of the chain. And is using the principles for the analysis. So we already are looking at that. in a limited way, with a limited look, and for only a certain sector. But if we see that something can come out of it, we will report. But that's, I would think, more or less covered, at least to some extent. Henry.
Thank you. And my first observation for those of you that were around 10 years ago, across the street when we had the 20th anniversary, there's a lot more going on than there was 10 years ago. There's a lot more recognition of the principles. There's a lot more use of the principles. And these are all very positive movements. So my hope is 10 years from now, for those of you that are still around, I probably won't be, we'll see even more progress in that regard. They'll be better known and more often used. As for the 5th edition, I'm going to do some work for the Institute right now. Let's suppose we appoint an expert group to determine whether we needed a 5th edition. The answer is going to be yes. Okay, and that should be rejected, in my opinion. So I get that out of the way. But joking aside, that's what's going to happen over the next umpteen years, is that it's going to be studied to see whether there's going to be a 5th edition, and it'll be knocked back and until it's not. And so there will be a 5th edition someday, I suspect, because that's just the nature of legal development. But let me suggest, from all the discussion and my thinking and work with it, why, and I'm talking about a new edition of the principles, not the commentary, because I want to come back to that in a second. People have made some wonderful points here. But, you know, we had the 1994, and then we looked to see what's not covered, and then the 2004, and what's not covered, and that was the 2010, and what's not covered, and that was the 2016. And that wasn't just creep. That was actually realizing there were areas of basic contract principles, because I don't think we need ever lose sight of what we're talking about with the principles. Basic contract principles. And there's only so many areas in basic contract principles that are out there. And there's the same sort of box that have been around for a couple thousand years. And we've pretty much covered the ground of basic contract principles. Someone suggests the 2016 edition didn't go that far with long-term contracts. It went as far as the working group felt it could do at the time. You know, that's the thing. It's you could only do so much, which is why I think Ignacio's suggestion that the immediate future, and I don't mean like the day after tomorrow, but in the next, say, decade or so, or whatever, these sectorial applications is probably going to be a good part of the future. We're seeing it. We've discussed it yesterday, today, and I think we're going to see more of that. So I think where we are is a good place. The principles are becoming more widely used, better known. They seem to be doing a pretty good job. They have been adaptable to reinsurance and all of these other areas. Now, as to the comments and the examples, we all have as teachers some of our favorite examples. The CISG, everyone pulls out the same one, hovercraft. And there's a story of why it's excluded, and we all laugh and we show it to the students. I like to pull out the commentary and some of the examples and the principles and show them that they come from Roman law. And I don't mean the civil law. I mean the Roman law that you learned in law school when you took Roman law, like the sale of horses, right? And and those are the, and you kind of look at those and you say, is this really in the explanation of the principles of international commercial law? We probably might want to look, and there's been a lot of suggestion of the comments and examples. And I think that's a good suggestion. How that will get done, I don't know. That has to be thought about, but it's certainly a good suggestion of working in that regard. But as far as bright and shiny things, we like bright and shiny things. 5 years ago is Bitcoin, before it destroyed itself, and you know, and all of this stuff. electronic contracting and all the little things that go with it, most jurisdictions have pretty good rules that deal with electronic signatures and electronic contracting and the equivalent of electronic equivalent of a writing and this, that, and the other. And these are easily adaptable. Should we update the comments to make reference to those? Possibly, but not necessarily. And technology has changed a lot in our life, but it really hasn't changed basic contract rules. And that's the point I would emphasize. You know, what about smart contracts? Well, smart contracts are wonderful, except they're not contracts. But other than that, we ought to deal with them, right? You know, so it does seem to me that there's a strong sense of caution that we should take in moving forward with the principles and adapting the principles. I would not change the principles at this point. I do appreciate that sometime in the future, there will be a new edition because that's the nature of the world that we live in. But I don't see any urgency now. But again, a lot of comments on the comments, and I think that's a good suggestion. One last point: never touch things you can't solve, right? And that was always the guiding, one of the major, if not the major guiding principles that goes all the way back to the beginning of the principles. Resolve what you can, do it well, but don't get into areas that you cannot come up with solutions. That's why UNIDROIT doesn't deal with consumer contracts, because you can't come up with an international standard for consumer contracts. I wouldn't touch good faith with a 10-foot pole. And that's because we're not going to be able to resolve what that means to a level of certainty, even with general vagueness, a level of certainty that we should put in, and this is my opinion, that we should put in an instrument that deals with international commercial contracts that are designed to be used internationally. So that's my good faith suggestion of what we should do with good faith. And with that, I'll finish my comments. Thank you.
Would you like to react to that? I think you should.
I do agree that it is a very complicated task, and that probably will dissatisfy half of the room, because those who accept one understanding of good faith are probably closer to that particular understanding, and the others, they will not, and they will think that it's not a good solution. On the other hand, Article 1.7 says good faith is a general principle and the parties cannot deviate from it by agreement, which is already a very, very hard thing to say in a soft law instrument. And then good faith is mentioned in 37 different provisions, and then it is underlying the whole instrument. So leaving it like that, knowing that you are, I know it's a Pandora, whatever it's called in English, box. Yeah. So I don't know whether the right solution is to ignore the problem and live with it.
I would be happy to really go at that issue as long as we could agree that I would personally get to reopen all the issues that I lost during all the negotiations. And I'm looking at some people that were on the losing side with me. I'm joking. But I mean, there were a lot of compromises that were made along the way. And if my memory serves me well, one of the compromises was we would mention good faith, but we couldn't nail it down because the group in the room, we never could nail down a definition of good faith. Anyway.
Stefan.
Yeah, thank you. Referring to this debate on whether UNIDROIT should issue a document clarifying what good faith means. As Roman law was just invoked, there's a very ancient maxim called lex ubiat nec disputat. UNIDROIT is a legislator in this field, a legislator of soft law. And I think it's one of the big achievements of the principles to have discussed extensively the comparative backgrounds in the travaux préparatoires. You can, in the working group meetings, you can read the travaux préparatoires. You can see exactly the positions that were exchanged. But I really don't think it's the function of UNIDRA to write academic treatises on the meaning of good faith, whether operational or less operational. There is, I mean, that's the role of scholarship. And there are, by the way, good commentaries that actually do exactly that, and I think it would be almost an overreach by UNIDRA doing that, and it would be detrimental, because what you want to have is an instrument that can adapt, that can be developed in specific cases by different courts, by different arbitration tribunals. And if you started to be prescriptive or overly prescriptive, I think it would be positively harmful.
Thanks. We're expecting the new edition that everyone is.
You know, it's interesting what you said. I've been a delegate to UNCITRAL for over 40 years, and we had a secretary, Gerhard Herrmann, a wonderful German gentleman, and we finished work on the procurement law. I was the chief delegate to that as well, and I said, "What about a guide to enactment?" "Oh no, I may use a different word, commentary." "Oh no, only professors." I have come from a family of some German law professors. I don't wish them on you necessarily. He said only professors can prepare this sort of abstract analysis, and I agree. But what we think we need is not abstract analysis, but possibly a series of practical examples bringing out, because it's very clear that good faith is a mysterious, unboundaried expression. There's no question about it, and to deny it, I won't compare anyone to an ostrich, but.
Okay. Roy takes the last floor.
Oh, thank you very much. I certainly don't think we should try to define good faith. I think it would be a great mistake. And in fact, I've always thought there's nothing like a healthy dose of uncertainty to promote a reasonable settlement. So there is some merit in that. I think that when well, actually, I'm happy to say I've forgotten the second part of my argument, so we can end with.
Happens to me all the time. So it's Philine's turn now.
Thank you very much. So strictly related to panel 5, which concerns the role of the UPICC in shaping legislation, I would highlight 2 points and building up on that, the concrete proposal. First, we consider in the panel the direct influence of the UPICC on legal reform of general contract law, but those instruments that were mentioned, the legal guide on contract farming, for instance, that were modeled along the UPICC, they have influenced legislation also and very strongly. So the legal guide concerns agricultural producer contracts and provides often with assistance by FAO, which was one of the partner organizations that developed the guide, provides concrete guidance for countries to regulate or legislate on agricultural producer contracts. And there are more than 5 countries that only with assistance from FAO have adopted legislation on this. So this indirect influence of the UPICC through instruments that were developed and modeled along the UPICC, I think is quite impressive. The second one is we thought of these traditional categories of national and regional legislation, but another interesting case are special economic zones, which are typically they have a set of regulations that differs from the main legal order of a certain country. And so the UPICC are actually a very interesting neutral model that could serve for regulating the contract law. And we have 2 concrete examples just to mention from the region that we addressed today. These examples were not addressed. The Dubai International Financial Center and the Qatar Financial Center. Both issued contract law and contract regulations 2004 and 2005. And not only the structure of these closely mirror the UPICC, but there are many articles that are simply copy-paste from the UPICC. Interestingly, for Dubai, for instance, the 2 articles concerning interest. Exactly. So this is a very interesting other category to consider. I mean, category of regulation. And
because much of this is not really known, it might be interesting to prepare some more detailed overview, and maybe with an interactive map that could be on the homepage where one could click on a certain country, for instance, or get information about the legislation, legal reforms that were actually based on the UPICC or one of the linked instruments. So this was concerning our panel. Then if I may go beyond this with just 2 or 3 ideas, very quickly. The important role of the UPICC in legal education was highlighted a few times. And one idea could be to establish a proper UNIDROIT moot court competition that focuses on the UPICC, for instance, by UNIDROIT, maybe in partnership with a university or other institution, but really that has this brand. The UPICC even more popular and visible among younger generations. And then with regard to promotion activities, we heard again from Mina this time specific reasons for their lower usage, and they are very much specific to that particular context. So maybe the promotion activities need to be more tailored towards this particular context where the UPICC would be used, because the strategy needs to respond to these reasons for lower usage. This could be combined with regional conferences, for instance, where practitioners can exchange, practitioners that have a similar framework conditions. Last point, I think also in promotion activities, it could be interesting to partner more with other organizations such as UNIDROIT in their field promotion activities and highlight how these instruments can be operationalized together. Thank you.
Thank you.
Listening to the next to last suggestion, of course, we all get 10 emails a week on special programs. Some are very expensive, some are not. But for example, the Practicing Law Institute of the United States puts on endless programs. They're quite specific, and there's a demand for them. Now, whether there's a demand for the principles, I don't know. But if there were, it's a natural, right? It's a 1 or 2 day thing. It's promoted purely for commercial, serves a higher purpose, but it's motive for commercial. Maybe there must be lots of these organizations around the world constantly hustling these programs, and maybe we suggest to all of them, how about having twice a year the principles or something like that?
I think before Anna has the final, I think we don't have the time really to discuss whether it would make sense to try to adapt to some extent the principles to Sharia law in order for them to be applied in Sharia law countries. But perhaps a secretariat's note or some sort of paper could be drafted together with experts that would then inform the governing council. I think this is an area which we might want to pursue to gain more knowledge of the compatibility between UPICC and Sharia law, and then take it from there and see if it makes sense to continue that road or just leave it at that. But I thought your presentation was very important, and that's something we need to consider. Anna, your panel was the last. We don't have much time, but please.
I think I have already talked about what were my suggestions. I don't think that directly from the panel we had there are further suggestions beside the fact that more promotion and perhaps also tailored promotion to certain regions or to certain users of the UNIDROIT principles might be useful, and this was already said. And in particular, just one point I wanted to raise. I know that there is not a great appetite, and there was not in the past, in introducing into general contract law the issue of developing technology, because it becomes very quickly obsolete again, because it goes on, and there are already other instruments from other organizations that can work very well together, and so that perhaps there's no need. But some of the changes that we are seeing now with the use, for example, of platforms or other ways of contracting. I'm not saying that this is necessarily something that should be studied or added, but at least the idea of thinking about examples on how general contract law interacts with this type of contract making or maybe contract performance might be useful. Connected also to the application of the UNIDROIT principles in relation to national law, which is what was the content of our panel. Thank you.
Thank you. Okay, one last intervention, please.
This may be controversial, but I must say it anyway. And that is what you were saying about Sharia law. I personally think that the title UPICC or UPICC and Sharia is not really very relevant, because having worked for many years on disputes in the Middle East, there's only one dispute I can think of where the dispute was settled by reference to Sharia law, and that happened to be in a country which was the Maldives, where the contract had been signed before there'd been any new codifications. But in all the other major countries of the Middle East, there are civil codes, modern civil codes, and that, in my experience, international commercial disputes are settled by reference to those codes, which were originally based on the French civil code, but they've been modified by Arab lawyers. So I do not, Sharia law is very important, I know, in family matters in the Middle East, but when it comes to commercial contracts, they're not settled, in my experience, by reference to Sharia law, but by reference to the code provisions of the contract.
Excellent. So it will be a short research that we'll undertake, and your opinion is obviously very valid. I would like to just, I mean, it's obviously not possible to summarize, but there seems to be a relatively a positive feeling about the possibility of continuing to develop the principles sectorially when the opportunity comes and arises and is justified. Some good ideas, construction contracts might be one of those. Some interesting ideas about dispute resolution and the principles, which could also not only be a separate part, but also feed into, for example, the remedy in hardship, which is renegotiation, and how to structure that through some sort of mediation or alternative dispute resolution systems. Technology, maybe not yet, but to some extent will need to be factored in at some point. When that happens, we will need to do it. This is something we need to do with all our instruments, not just with UPICC. So it might be necessary. I'm not sure there was consensus about good faith. There was agreement to disagree. Some people were very keen, some others were less keen. There were a number of very useful proposals concerning application, dissemination of the principles and ways to reach out to a larger crowd. I think it would be interesting for everyone to consider whether we should move towards competing with the VIS court mood and try to do something ourselves with the principles, or that's just impossible because it's too consolidated. So these are ideas that have been thrown out there for us to do, and I think they were hugely useful, as these 2 days have been greatly successful, and everyone's at the Secretariat is really appreciative of all your comments and your help. Thank you so much for being here. The last thing that we have now, apart from, please join me in thanking all the chairs. Is to present the final speaker of the day. We have now with us Professor Arthur Hartkamp, 40 years member of the Governing Council, our doyen, a person who has done so much for our institute and who decided not to run again in December. We thought it was beyond fair that we offered him a tribute today and through the Governing Council if he wishes to stay. And he is kindly agreed to come and summarize and provide some reflections of his own. So Professor Hakam, if you would kindly step, I think two of us.